Hey, I'm live. The goal is just to get a great tan for after the bar, but the goal is actually for this is to read an outline in which partnerships and limited liability companies, um, rather than reading the entire text, my intent is by reading the table of contents and what I wrote in the margins that should provide the detail necessary. However, I can see that I only wrote in the margins on like 2 pages, so actually going to change it up and read the first 6 pages, go to the short outline version, skip like 13 pages. In fact, actually, I'm going to read a shorter outline. Pardon. So we're going to read up into rights of partner and partnership property. Okay, so rights of partner and partnership property. All right, so we're going to read five pages from the shortened outline. Go through 13 pages of material in an outline format, and then proceed to finish in the shortened outline. Just trying to make time. In general, a partnership is an association of 2 or more persons to carry on as co-owners a business for profit. Partnership law is based on the law of contract and agency. Remember that there must be at least 2 persons involved in forming a partnership. A partnership may not exist with only one partner, but also remember that a person may be an individual, trust, corporation, partnership, or other entity. Thus, partnership A and corporation B can agree to form partnership C. B, letter B in this nature of a partnership section is partnership is a legal entity except with respect to partners' personal liability for partnership obligations. A partnership is a legal entity distinct from its partners. Title to land may be in the partnership name. A partnership may sue or be sued in the partnership name, which would be the entity theory or approach as opposed to the aggregate approach. Governing law. Generally, the Revised Uniform Partnership Act, RUPA, provides a default set of rules. Partners are free to agree through a partnership agreement to abide by different rules for governing the relationship among themselves, and the RUPA will govern only those issues not provided for in the partnership agreement. Note, however, that certain RUPA provisions cannot be waived. Example, the duty of loyalty, the right of a court to expel a partner. Part 2, formation of a partnership. How a partnership is formed. A partnership is formed as soon as 2 or more people associate to carry on as co-owners of a business for profit. Agreement. No formal agreement is required to form a partnership. The parties' intent may be implied from their conduct. Writing, generally not required. No writing is required to form a partnership. However, because of the statute of frauds, if partners wish to have an enforceable agreement to remain partners for more than 1 year, they generally must execute a writing reflecting their agreement. Capacity. Anyone who is capable of entering into a binding contract may be a partner. A would-be partner who lacks capacity is liable only to the extent of his capital contribution. but the partnership with such person is not void. It will continue to exist until steps are taken to dissolve it. Legality of purpose. A partnership formed to achieve an illegal purpose is void, and the courts will not compel an accounting or a settlement of a void partnership's affairs. Consent, unless otherwise agreed, no one can become a partner without the express or implied consent of all partners. Statement of partnership authority. A partnership may choose to file a statement of partnership authority with the Secretary of State, which can give constructive knowledge of the extent of the partner's authority with regard to the partnership. Proof that a partnership exists. Since no formalities are required to form a partnership, it is sometimes difficult to determine whether the relationship between the parties is a partnership or something else. To determine whether a partnership exists, courts generally look to the intent of the parties. If they intended to carry on as a business as co-owners, there is a partnership event. If they did not subjectively intend to be partners, where the parties' intent is uncertain, the courts consider the following rules. 1. Sharing of profits raises a presumption of a partnership, and 2. Evidence indicative of a partnership. So, sharing of profits raises the presumption of partnerships unless the share was received as payment of a debt for services rendered, as rent payment, as an annuity or other retirement benefit, as interest on a loan, or for the sale of goodwill of a business. Evidence indicative of partnership. Following factors may be additional evidence that the partnership has been formed. However, in contrast to the sharing of profits, these factors do not raise a presumption of partnership. Title to property is held in joint tenancy or in joint tenancy in common. The parties designate their relationship as a partnership. C and D. D is sharing of gross returns, but C is the venture undertaken by the parties requires extensive activity. For example, A and B each contribute $100,000. The ladybug just fell on my table. All right, so when A and B contribute $100,000 to buy a building of rental apartments that must be managed, it is more likely that they are partners than if they each contribute $100,000 to buy shares in a company that manages real estate. And again, the sharing of gross returns. Sometimes exam questions will merely describe the relationship among parties involved in a business and will ask about the rights of the parties among themselves or about the liabilities of the parties for obligations of the business. In such questions, you must determine whether there is a partnership. Do this by considering and discussing the factors above. Remember that the sharing of profits generally raises a presumption of partnership, but the presumption can be rebutted by other factors indicating that a partnership was not intended. Purported partners. 1. Liability of person held out as partner. When a person by words or conduct represents himself as a partner or consents to being, oh no, I've lost page 3 and 4. So they've consented to being these purported partners. Represented by another as a partner, she will be liable to third parties who extend credit to the actual or parent partnership in reliance on the representation. See RUPA Section 308. No duty to deny partnership. Note that a person held out by another as a partner is not liable as a partner unless she actually consents to the holding out. Mere failure to deny a representation of partnership does not give rise to liability as a purported partner. Thus, the mere fact that one fails to deny partnership status when named by another in a statement of authority, or a partner's failure to file a statement of disassociation after leaving a partnership does not alone give rise to liability as a purported partner. Again, the same section of RUPA is cited. Liability of a person who holds another out as partner. When a person by words or conduct holds another person out to be her partner, she thereby makes the alleged partner her agent with the power to bind her to third parties as if the other were in fact a partner. Note that if the person making the representations is in fact a member of an already existing partnership and the representation is to the effect that the would-be partner is a member of this partnership, only those partners who made or consented to the representation will be bound. Property of a partnership. In addition to testing whether a partnership existed, partnership questions often focus on rights and liabilities as between partners and third parties, both in the ongoing conduct of the partnership and in the eventual dissolution. In analyzing such issues, it may be important to distinguish which property belongs to the partnership and which belongs to the individual partners. If the property belongs to the partnership, how should it be characterized and what are the rights of the individual partners in that property? Classifications of property. Partnership capital. Partnership capital consists of the property or money contributed by each of the partners for the purpose of carrying on the partnership's business. That's the partnership capital. Partnership property, in its broadest sense, embraces everything that the partnership owns, consisting both of the capital contributed by its members and the property subsequently acquired in partnership transactions. Now, what is includable in partnership property? And one is titled property, two is untitled property. All right, so we're soon going to be able to jump over to this shorter outline. There is no restriction on what may be partnership property, and sometimes it is not always obvious whether property is partnership property or the individual property of a partner. The RUPA has a number of provisions concerning ownership of titled property, both titled personal property and real property. For example, that is not for property that is not titled. The common law has developed a number of criteria to analyze, which is interesting because the first section is titled property according to RUPA provisions. Property deemed to be partnership property. Under the RUPA, titled property is deemed to be partnership property if it is titled in the partnership name or it is titled in the name of one or more partners and the instrument transferring title notes the title holder's capacity as a partner or the existence of a partnership. That's from section 204 of RUPA 1 and 2. Now, for a partner or property presumed to be partnership property under the RUPA, property is rebuttably presumed to be partnership property if it was purchased with partnership funds, regardless of in whose name title is held. Again, same section of RUPA. Partnership funds includes not only the partnership's cash, but also the partnership's credit. Property presumed to be partners' separate property under the RUPA if one property is held in the name of one or more partners. Two, the instrument transferring title does not indicate the person's capacity as a partner or mention the existence of a partnership. And three, partnership funds were not used to acquire property. The property is rebuttably presumed to be separate property, even if the property is used for partnership purposes. So that's the presumption elements, and which is a little bit. Just read them again. Does not indicate the instrument transferring title is not indicative of the person's capacity as a partner or mention the existence of a partnership. Partnership funds were not used to acquire the property. Thus, the partner's individual property, not the partnership property, even if it is used for partnership purposes. For untitled property, this is the common law criteria we were just talking about in cases not governed by explicit group of provisions, in cases of property that is not titled. In determining whether property is partnership property or the separate property of the partner, courts will probably continue to look to the following common law criteria, which tend to indicate that the property was intended to be partnership property. A, acquisition of the property with partnership funds. B, use of the property by the partnership in conducting the partnership's business. C, entry of the property in the partnership's books as a partnership asset. D, a close relationship between the property and the business operation of the partnership. E, improvement of the property with partnership funds and maintenance of the property with partnership funds. Rights of a partner in a partnership property. A partner is not a co-owner of partnership property and thus has no transferable interest in specific property of the partnership. It is important to remember that a partner has no right to use partnership property other than for the benefit of the partnership. The next section is partner's interest in the partnership. In general, each partner has a transferable interest in the partnership, which consists of his share of partnership profits, losses, and distributions. I'm hopeful I can move over to the outline we were just talking about. Actually, we can. So we read in general, the share of the profits. Interest is personal property transferable and attachable. This interest is treated as personal property transferable without dissolving the partnership and attachable. Note that absent an agreement to the contrary, a partner shares equally in the partnership profits and must contribute to the losses in proportion to his share of the profits. Note also that a transfer of a partner's interest in the partnership gives the transferee no rights with regard to the operation of the partnership. It merely entitles the transferee to receive profits in which the transferring partner would otherwise be entitled. A partner may not sell his partner status, i.e., may not make another a partner without the unanimous consent of the other partners. So for relations between the parties, there's a right to participate in management, that all partners have an equal right in the management of the partnership business absent an agreement to the contrary. Decisions involving ordinary business can be controlled by a majority vote of the partners, but matters outside the ordinary course of business require unanimous consent of the partners. That's kind of an important distinction, so I'm glad I read it. So majority rules tend to be the case unless they're deciding on a matter outside the ordinary course of business. Then I read into the fiduciary duties here. The duty of loyalty I've written as account to partnership benefits arising from partnership property opportunities. 2, not advance one's own interest. And 3, not to compete with the company, the partnership. So those are the 3 parts making up duty of loyalty. So you can't get paid for a job and then just make off with it. You have to count for it, even if it's opportunities that were presented to you for additional work. You can't just take that off, do it on the side. You have to present it to the partnership. That's what that first part means. But 2 is not to advance your own interests above that of the partnership. And 3 is not to compete with the partnership. Duty of care is to refrain from negligence, recklessness, intentional misconduct, or criminality. That makes up the duty of care. The duty of obedience is to follow the partnership directions and not to act outside of authority. 4, the that's the duty of obedience. Fourth is the duty to provide complete and accurate information, which would be as among the partners, fellow partners. Partners' accounts. Oh, I have another word's disclosure. So probably duty to disclose. Partners' accounts. When do we get to that? Interesting. It's like, that was only one paragraph. Could have just as easily read it. Each partner is deemed to have an account that is credited with the amount equal to the partner's contribution of capital plus his share of any profits, and debited with the partner's share of any losses and partnership liabilities. Where a partner personally profits at the expense of a partnership, the partner must account to the partnership for these profits. Remuneration. Absent agreements to the contrary, a partner has no right to remuneration for his services rendered to the partnership except for reasonable compensation for services performed in winding up the partnership business. When a partner has impliedly or expressly promised to devote time to the partnership business and fails to do so, she may be charged in an accounting for damages caused to the partnership. Indemnification and other repayment. A partnership must indemnify every partner with regard to payments made and obligations reasonably incurred in carrying out the partnership business. If a partner makes a payment or advance on behalf of the partnership beyond the contribution the partner agreed to make, the payment or advance constitutes a loan that must be repaid with interest. Rights upon dissolution. Upon dissolution, a partner is entitled to a settlement of her account. Books and information. Books and information must be kept at the partnership's chief executive office. Each partner has a right to inspect and copy the partnership books. Upon demand, each partner must render true and full information of all things affecting the partnership agreement. All right, so we're going to skip some pages about legal actions by and against the partners, but it discusses how a partnership may be sued, actions by partnership against partners, and actions by a partner against partnership. And relations of partners to third parties. Okay. In general, application of the law of agency, apparent authority is discussed, business of the kind. When a decision is within the ordinary course of a partnership's business, or business of the kind is what is meant by business of the kind. Obviously, there's apparent authority for a partner to be able to bind the partnership. Limitation is when a third party has knowledge or has been notified of a lack of actual authority on the part of a partner. Transfers of partnership property, where the partnership interest is indicated, where a partnership interest is not indicated, and where one person holds all partners' interests. Those are all different kind of hypos. I wonder if I don't want to go to that page and maybe elaborate. So I'm going to go to page 10, actually in the longer outline. Just note that if you're suing, so back to legal actions by and against parties, if you're suing a partnership to reach a partner's personal assets, there must also be a judgment against the partner. Actions may be brought against the partnership and the partners in the same action. Like actions by the partnership against partners, the partnership may bring an action against a partner for breach of a partnership agreement or violation of a duty. Actions by a partner against a partnership. A partner may bring an action against the partnership or other partners for legal or equitable relief to enforce any right. created by RUPA, created by the partnership agreement, or otherwise belonging to the partner, including rights arising independently of the partnership, i.e., a partner may sue the partnership for negligently inflicted injuries, or on contracts where the partner stands in the position of a customer of the partnership and RUPA. Such actions include an equitable action for an accounting in which all the transactions among the partners are sorted out and the net amount owed or owing to each partner is determined. Relations of partners to third parties is the next section. And this is where we're talking about apparent authority. RUPA provides that to an act of any partner for apparently carrying on in ordinary course of partnership business or business of the kind carried out by the partnership binds the partnership unless the partner had no authority to act and the person with whom the partner was dealing knew or had received notification that the partner lacked authority. So I just kind of said that. I defined business of the kind already. They're then defining new or received notification on the part of the third party. Knowledge means subjective knowledge about what the person actually knew. What the person should have known is based on the circumstances is irrelevant. Notification is effective either when it comes from the person's attention or when it is duly delivered. Thus, if a notification limiting a partner's authority is duly delivered to a third party at the third party's place of business, the third party cannot rely on the apparent authority with regard to the limitation, even if the third party has not actually read the notification. Transfers of partnership property. There were 3 different kinds in the outline. There is where partnership interest is indicated. If a partnership is held in the name of a partnership, any partner may execute an instrument transferring the property in the name of the partnership. If the property is held in the name of one or more partners and the instrument transferring the property indicates their status as partners but does not name the partnership, the transfer may be effected in the names of the persons in whose names the property is held. In either case, if the transferring partner did not have actual or apparent authority to make the transfer, the partnership can recover the property from the initial transferee. The initial transferee has transferred the property to a subsequent transferee who gave value without notice that the person who transferred to the initial transferee lacked authority. The property cannot be recovered. Where partnership interest is not indicated in partnership property, if partnership property is held in the name of one or more partners and the partnership's interest is not indicated in the instrument transferring the property, the transfer may be effected by the persons in whose name the property is held. The initial transferee takes free of the partner's or partnership's interest as long as the transferee gave value without notice that the property was partnership property and that the transferring partner was without actual authority to transfer. Where one person holds all interests. If a person holds all of the partner's interest in the partnership, all of the partnership property vests in that person. Section 302 of RUPA is actually where all of these come from. Actual authority is the partnership will also be bound by an active partner if the partner had actual authority. And then we get into the voting of the partners. Majority vote is sufficient. To grant a partner actual authority. Exceptions requiring unanimous vote. Acts outside the ordinary course of the partnership business and amendments to the partnership agreement require unanimous vote of the partners. So these voting details have to do with changing the partnership and providing authority. Expanding and limiting authority, statement of authority. There's the general rule, there's transactions other than real property transfers, transfers of real property, statement of denial. Then notice, when notification is effective, notice is imputed to the partnership, and then Liability of partners, I have in quotations guarantors. I also have in the margin joint and several liability and the exhaustion rule. Civil liability, types of civil liability, contract liability, tort liability, nature of the partner's liability, extent of the partner's liability, change of the partnership membership as affects partner's liability, liability of incoming partner, liability of outgoing disassociated partner, and criminal liability. So, rather than just going right into the disassociation and dissolution of a partnership, I realized this is actually fairly important. Fairly important to understand the liability of the partners. So, types of liability we were talking about under civil liability, starting with contracts entered into by a partner in the scope of the partnership business or with authority of a partnership. Similarly, partners also are liable for all torts committed by any partner or employee of the partnership within the ordinary course of partnership business or within authority of the partnership. Nature of liability. Liability is joint and several. One or more partners may be sued for all the obligations of the partnership, whether arising in tort or contract. A judgment is not personally binding on a partner unless she has been served and the creditor has exhausted partnership assets, or exhaustion is excused by agreement or court order, or because the partnership is bankrupt. Extent of liability. Each partner is personally and individually liable for the entire amount of the partnership obligation. A partner who pays more than his fair share of an obligation is entitled to contribution from the other parties, and a partner who pays the whole obligation of a partnership is entitled to indemnification. Liability of an incoming partner. An incoming partner is not personally liable for obligations incurred by the partnership before that person became a partner. Liability of outgoing disassociated partner. An outgoing or disassociated partner remains liable for obligations arising while he was a partner unless there has been payment, release, or novation. An outgoing partner can also be liable for acts done after disassociation. Examiners often test the difference in liability between an incoming partner and also the liability for acts done after association. An outgoing partner. Remember, an outgoing partner generally remains liable for all partnership obligations incurred while he was a partner, whereas the incoming partner generally has no liability for obligations incurred before she became a partner. Criminal liability. Partners will not be criminally liable for the crimes of other partners committed within the scope of the partnership business unless the other partners participated in the commission of the crime either as principals or accessories. Disassociation and dissolution of a partnership. Disassociation is a change in the relationship of the partners caused by the partner ceasing to be associated in the carrying on of the business. Disassociation of a partner does not necessarily cause a dissolution and winding up of the partnership business. Events that cause this: oral or written notice of the partner's express will to withdraw, happening of an agreed event, valid expulsion of a partner, the partner's bankruptcy, the partner's death or incapacity to perform partnership duties, the decision of a court that the partner is incapable of performing partnership duties, and the termination of a business entity that is a partner. right? So there's 7. Rule or written notice, happening of an event, valid expulsion, bankruptcy, appointment of a receiver, death or incapacity, court decision on capability to perform, or termination of a partner that is a business entity, termination of a business entity that is a partner. So the consequences of a disassociation is liquidation or buyout. I didn't go over the wrongful dissolution. Unlike other events of dissolution, notice of a partner's express will to withdraw from partnership at will automatically triggers dissolution of the partnership. If an essay question sets up a situation where a partner notifies his co-partners of an express will to withdraw from the partnership at will, you could discuss both disassociation and dissolution. So the consequences, I wrote liquidation and buyout. A partner who wrongfully disassociates before the expiration of a partnership term or completion of particular undertaking is not entitled to payment of the buyout price until the term expires or the undertaking is completed, unless he can establish that earlier payment will not cause undue hardship to the partnership's business. Interest must be paid on the buyout price from the date of disassociation to the date of payment. So in general, okay, so that's kind of like the buyout. So I said liquidation and buyout or dash buyout. That's kind of the buyout function, and it can be stalled unless the buyout can be effectuated without undue hardship. In general, purchase of disassociated partner's interest, indemnification of a disassociated partner, deferred payment if premature disassociation, disassociated partner's power to bind the partnership. A partnership can be bound by an act of a disassociated partner undertaken within 2 years after disassociation if 1, the act would have bound the partnership before disassociation, and 2, the other party to the transaction, A, either reasonably believed the disassociated partner was still a partner, and B, did not have notice of disassociation. B, disassociated partner's liability to other parties. A disassociated partner can be liable for obligations incurred by the partnership within 2 years after the partner disassociates when 1, entering the transaction, the other party reasonably believed the disassociated partner was still a partner, and 2, did not have notice of the partner's disassociation. Note that a disassociated partner can cut short this period of liability by filing a notice of disassociation with the Secretary of State. All persons are deemed to have notice of a disassociation 90 days after such notice is filed. Dissolution at will is an example of a dissolution. Term at the end of the stated term for disassociation not required. Okay. So I'm not really making any sense out of my notes of this section. So, but is this not shorter? This is not shorter. This cannot be shorter. No. So just going to keep on reading basically out of the outline from here. Unlike disassociation, dissolution generally requires the partnership business to be wound up. Dissolution of a partnership at will, when a partnership is formed with no particular undertaking or definite term, it is said to be a partnership at will. A partnership at will can be dissolved at any time by the express will. For example, notice of dissolution of any partner without penalty. Events causing dissolution. The following events trigger dissolution under RUPA. In a partnership at will, notification of any partner of an express will to withdraw as a partner, that causes a dissolution. 2, in a partnership for a definite term or particular undertaking, 1, expiration of the term or completion of the undertaking. 2, consent of all the parties. And partners to dissolve, or 3, within 90 days after a partner's death, bankruptcy, or wrongful dissociation, at least half of the remaining partners wish to dissolve. Third, the happening of an event agreed to in the partnership agreement that requires winding up of the partnership's business. 4, the happening of an event that makes it unlawful for the partnership to continue. 5, issuance of a judicial decree on application by a partner that 1, the economic purpose of the partnership is likely to be frustrated. 2, the partner has engaged in conduct that making it not reasonably practicable to carry on the business. Or 3, the business cannot practicably be carried on in conformity with the partnership agreement unless issuance of a judicial decree on application by a trustee of the partner's interest that it is equitable to wind up the partnership, 1, after the term expires, where the undertaking is completed in a partnership for a definite term or a particular undertaking, and 2, at any time in a partnership at will. Partners' power to bind the partnership after dissolution. A partnership can be bound after dissolution by any act of the partner appropriate for winding up the partnership's business. The partnership will also be liable for other acts if the party with whom the partner dealt did not have notice of the dissolution. Such liability can be limited by filing a statement of dissolution with the Secretary of State. All persons are deemed to have notice of a dissolution 90 days after a notice is filed. Partnership continues after dissolution. The partnership continues to exist after dissolution until the partnership is wound up. Who may wind up? As a general rule, all living partners have a right to participate in the winding up of the partnership's business, except partners who have wrongfully dissolved the partnership and bankrupt partners. If all partners have died, the legal representative of the last surviving partner may wind up. Partners may waive dissolution and continue the business. Anytime before the winding up of a partnership business is complete, the partners may decide to waive the dissolution and continue the partnership by unanimous vote of the partners who have not wrongfully dissolved. Such waiver does not affect the rights of persons who have relied on the dissolution before receiving notice of the waiver. Distribution of assets, order of distribution. Partnership assets are reduced to cash, and partnership liabilities are paid in the following order. Creditors, including partners who are creditors, and partners' accounts. Partner who pays more than his share entitled to contribution, where a partner is forced to pay more than his share of the partnership's debts, he is entitled to contribution from the other partners to equalize the shares. Limited liability partnerships. The RUPA allows the creation of limited liability partnerships. The major advantage of operating as an LLP is that partners are not personally liable for LLP obligations. Formation, voting, the terms and conditions on which a partnership becomes an LLP must be approved by whatever vote is necessary to amend the partnership agreement, or if specified, the vote necessary to amend the contribution obligations of the partners. If the partnership agreement is silent as to how it may be amended, all partners must approve the terms and conditions of the partnership becoming an LLP. Filing. To become an LLP, a partnership must file a statement of qualification with the Secretary of State. The statement must be executed by at least 2 parties and contain such information as 1, the name and address of the partnership, 2, a statement that the partnership elects to become an LLP, and 3, a deferred effective date, if any. The partnership becomes an LLP at the time of filing the statement or on the date specified in the statement, whichever is later. Name. The partnership name must end with the words Registered Limited Liability Partnership or Limited Liability Partnership, or the abbreviation RLLP. RLLP, LLP, or LLP. So the difference is that there's periods between all the letters in the acronym, and it can be done without the periods. So liability. A partner is an LLP. A partner in an LLP is not personally liable directly, indirectly, or by way of contribution for the obligations of the partnership, whether arising in contract, tort, or otherwise. However, a partner remains liable for his own wrongful acts, and if partnership assets are insufficient to indemnify her for an obligation she incurred on behalf of the LLP, she forfeits the right to receive contributions from other partners in exchange for being released of the obligation to contribute to their personal liability. Limited partnerships. Introduction. Limited partnership is comprised of one or more general partners and one or more limited partners. The general partner a general partner is personally liable for partnership obligations, while the limited partner generally does not have any liability beyond the liability to make agreed upon contributions. A limited partnership differs from a general partnership in that a limited partnership can only be created by filing a certificate of formation with the state. Like a modern partnership, a limited partnership is an entity distinct from its partners and has perpetual duration unless otherwise provided. So that's the whole definition of limited partnership. I just find it strange that limited liability partnerships came first. So, operating as an LLP is that partners are not personally liable. Does require a partnership agreement. Does require filing with the state. Does require special name requirements. And really, no partners in an LLP are personally liable. So there isn't a quote general partner. So in the limited liability partnerships, versus the limited partnerships, limited partnership has to have at least one general partner and one limited partner, whereas limited liability partnerships, they're all limited partners. All right, so moving on to formation. A certificate of limited partnership must be filed with Secretary of State. The certificate must be signed by all general partners and set forth the name of the partnership, the names and addresses of the agent for service of process, in each general partner, and whether the limited partnership is a limited liability limited partnership. Records Office. A limited partnership must maintain in its state of organization an office with records of the certificate, any partnership agreements, and partnership tax returns for the 3 most current years. The partnership agreement or some other record must contain the amount and description of each partner's contribution, special rights of partners regarding distributions, etc. Agent for service of process. A limited partnership must maintain in the state an agent for the service of process. It is important to remember that a limited partnership is a creature of statute and thus can exist only in compliance with the limited partnership statutes. Watch out for exam questions that set up facts where one partner wants limited liability and the other partner tells him that he can be a limited partner, but there is no filing with the Secretary of State. Because there is no statutory compliance, limited partnership is not created and all partners are subject to full liability. Name of partnership. The partnership, that was an exam tip. The partnership name can only contain the name, may contain the name of any partner, general or limited, and must contain the words limited partnership or the abbreviation LP unless the limited partnership is a limited liability limited partnership, in which case that must be reflected in the name LLLP. Passing on, admission of additional general or limited partners. A person may be admitted to the general partnership as a general or limited partner as provided in the partnership agreement as a result of a merger conversion, or on the consent of all partners. Partner contribution. A partner has no rights or distributions unless the partner makes a contribution to the partnership. A contribution may be in the form of any benefit to the partnership, for example, money, property, services, and promises to make such contributions. A partner's contribution obligation is not excused by death or other disability and may be compromised only on the consent of all partners. Note, if a partner fails to make an agreed upon non-monetary contribution, example, the partner fails to provide promised property or services, the limited partnership has the option of seeking cash in lieu of the agreed upon contribution. Liability of partners. Liability of general partner. Except as provided by statute or in the partnership agreement, a general partner of the limited partnership is jointly and severally liable for all obligations of the limited partnership. Note, a general partner may also be a limited partner and have the rights of a limited partner, but such a dual capacity does not relieve the general partner of his duties as a general partner. Incoming partners. A person who becomes a general partner of an existing limited partnership is not personally liable for an obligation that the limited partnership incurred before he became general partner. And limited liability, limited partnership, liability incurred while a limited partnership is a limited liability. Limited partnership belongs to the partnership alone. The general partners is not personally liable on the obligation. So here I skipped a couple of pages within liability of partners. So, within the limited partnership. So I'm going to go to page 24 of the longer outline, liability of the limited partner. A limited partner is not personally liable for an obligation of the limited partnership solely by reason of being a limited partner. Note that earlier, limited partnership acts made limited partners personally liable if their names were used in the partnership name or they participated in the management of control of the partnership or control of the partnership. The ULPA no longer includes such provisions. One who erroneously believes herself to be a limited partner, a person who makes a contribution to a business enterprise and erroneously but in good faith believes that she has thereby become a limited partner rather than a general partner can avoid being held liable as a general partner if, on ascertaining the mistake, she 1 files a certificate of limited partnership or certificate of amendment with the Secretary of State, or 2 withdraws from future equity participation in the enterprise by filing with the Secretary of State a certificate declaring withdrawal. However, the person will still be bound as a general partner to any third party who actually believed in good faith that the partner was a general partner and transacted business with the enterprise before the partner took curative action. ULPA section 306. Duties of partners. Not much longer. General partner. General partner owes the limited partnership limited fiduciary duties of care and loyalty similar to those owed by a partner in a general partnership. Note that a general partner does not violate the duty of loyalty merely because the general partner's conduct furthers his own interests. Limited partner. Generally, a limited partner owes no fiduciary duty to the partnership and thus is free to compete with the partnership and have interests adverse to those of the partnership unless the partnership agreement provides otherwise. Of course, a limited partner still is bound by the duties of good faith and fair dealing regarding partnership matters. Rights of the parties, rights of both general and limited partners. Rights of distributions. Earlier limited partnerships acts gave partners discretion to provide for an allocation of distributions in the partnership agreement, but the YULPA no longer does this. The YULPA's provisions for distributions are very similar to the distribution provisions for corporations. On the basis of contributions, YULPA requires distributions to be made on the basis of partners' contributions in proportion to the value of each partner's contribution. According to Section 503. Note that this is different from the general rule under the RUPA, which provides that profits and losses are to be shared equally. So here under UPA, it's in proportion to the contribution made. Solvency requirements. A limited partnership may not make a distribution if, after making the distribution, a limited partnership would be unable to pay its debts as they become due, or the limited partnership total assets would be less than the sum of the total liabilities, including sums needed to satisfy superior preferential rights upon dissolution. That's from Section 508 of ULPA. Liability for improper distributions. A general partner who consents to an improper distribution is personally liable to the limited partnership for the amount that the distribution exceeds what could properly have been distributed. Any partner who receives an improper distribution, knowing that it is improper, may be forced to return the improper amount to the partnership. However, no personal liability for an improper distribution arises if the distribution appeared to have been proper based on reasonably prepared financial statements. ULPA, Section 509. Right to assign partnership interest. A partner's right to distributions is personal property that may be transferred in whole or in part. Such a transfer gives the transferee only the right to receive the transferred distributions and to demand an accounting thereon. The transfer does not make the transferee a partner or give the transferee any rights as a partner. Moreover, the transferring partner remains a partner, and the transfer does not constitute a disassociation or cause a dissolution. However, transfer of a partner's entire transferable interest in the partnership is a ground for expulsion, and if the partners unanimously vote for expulsion, that causes a dissociation of the partner. Partnership interest may be charged by judgment creditors. A partner's interest in the partnership may be charged by her judgment creditors upon application to a proper court. To the extent so charged, the creditor has only the rights of a transferee, as discussed above. Right to transact business with the partnership. Partner may lend money to and transact other business with the limited partnership, and generally has the same rights and obligations with respect to the transaction as a person who is not a partner. Oh. Okay, so actually we moved to the shorter outline. And the right to dissolve. Any partner may apply for a decree of dissolution if the limited partnership, whenever it is not reasonably practicable to carry on the business in conformity with the partnership agreement. Direct action against limited partnership by partner. I only have like 4 more pages, by the way. Direct action of limited partnership by a partner may maintain a direct action against a limited partnership or another partner for legal or equitable relief to enforce her rights and interests. Derivative action. A partner may maintain a derivative action to enforce a right of limited partnership if the partner first makes a demand on the general partners to bring an action to enforce the right, and the general partners do not bring the action within a reasonable time, or a demand would be futile. A derivative action may be maintained only by a person who is a partner at the time the action is commenced, or who was a partner when the conduct giving rise to the action occurred, or 2, whose status as a partner devolves upon him by operation of law or pursuant to the terms of the partnership agreement. from a person who was a partner at the time of conduct. Rights specific to general partners, management rights. Each general partner has equal rights in the management and conduct of the limited partnership's activities. Generally, any matter relating to the activities of a limited partnership may be exclusively decided by the general partner, or if there is more than one general partner, by a majority of the general partners. However, the approval of all general partners and all limited partners is required to amend the partnership agreement, to convert the partnership to a limited liability limited partnership. 3, dispose of all or substantially all of the limited partnership assets, property, outside the usual and regular course of the partnership's activities. And 4th, admit a new partner. Or 5th, compromise the partner's obligation to make a contribution or to return any improper distribution. Right to information. Did I say right to information? The general partner's right to information is similar to that of a partner in a general partnership. Indemnification. A general partner is not entitled to remuneration for services performed for the partnership. However, the limited partnership must indemnify a general partner for liabilities that she incurs in the ordinary course of the activities of the partnership. Page 18, again, out of 21. Rights specific to limited partners, management rights. Although limited partners have no stated statutory right to participate in the management or control of the partnership agreement may allocate such rights to limited partners as a matter of contract. Participation does not cause a limited partner to become personally liable for an obligation of the limited partnership. Right to information. Each limited partner has the right to inspect and copy any partnership records required to be maintained. Next section, disassociation. So, limited partners' rights are management rights and right to information. However, they don't actually have a statutory right to participate in the management of the partnership, but they may have management rights by the partnership agreement, contractually. And that does not force them to lose their limited partner status and become personally liable for an obligation, right? They do have a right to information, to inspect and copy it. Disassociation, the events that will cause disassociation of a partner in a general partnership will also cause disassociation of a partner, general or limited, in a limited partnership. Note that the limited partner has no right to disassociate before termination of the limited partnership. A general partner's right to disassociate is similar to the right of a partner to disassociate in a general partnership. Before going into the effect on the limited partner and effect on the general partner, let's look again at what reasons there are for partnerships to disassociate. I wrote here in a general partnership, right? No, in the limited partnership. Oral or written notice, happening of an event, valid expulsion, bankruptcy, appointment of a receiver, death or incapacity of a partner, a court decision on capability to perform, and the termination of a business entity that's serving as a partner. The effect on the limited partner. After disassociation, a limited partner is treated as a transferee of the limited partner's transferable interest. Effect on the general partner. The effects of disassociation on a general partner in a limited partnership are similar to the effects of disassociation of a partner in a general partnership. So disassociation in a general partnership Oh, that's actually what I read, isn't it? Yeah, that is what I read. But if I wanted to look it up for reasons why disassociation occurs in a limited liability partnership, I will go to page 27 and just read what's kind of bold, which is maybe I'm just crazy. No, because it's corporations. Okay. It doesn't give me the specific reasons. It just says the events that will cause disassociation of a partner in general partnership will also cause a disassociation of a partner in general or limited in a limited partnership. A partner in a limited partnership may also disassociate through a merger with or conversion to another business entity. Note that a limited partner has no right to disassociate before termination of a limited partnership. The general partner's right to disassociate is restricted to a similar extent as the right of a partner to disassociate in a general partnership. So, I go back to the original list. Oral written notice, happening of an event, valid expulsion, bankruptcy, appointment of a receiver of any, one partner, death or incapacity of a partner, court decision on capability to perform and the term of a business entity, termination of this entity that's serving as a partner. On page 16, you'll see how there is differences between the types of partners disassociating. So when a partner disassociates, the partner's right to participate in management ceases. The partner's duties of care and loyalty generally are also terminated, except with respect to matters arising before the disassociation. Dissociation does not necessarily cause a dissolution of the partnership. I don't really see how it's different for limited or general partners. So let's go back to this. Dissolution and distribution. Dissolution in general, a limited partnership may be judicially dissolved upon application of a partner if it is no longer reasonably practicable to carry on a limited partnership in conformity with the limited partnership agreement. A limited partnership may also be administratively dissolved by the Secretary of State for failure to pay fees or file an annual report, but the partnership may apply for reinstatement by curing the defect within 2 years of the dissolution. Otherwise, a limited partnership may be dissolved only upon the occurrence of one of the following, which is the happening of events specified in the partnership agreement, consent of all general partners and limited partners holding majority of the right to receive distributions, majority in interest, after disassociation of a general partner, upon consent of partners owning majority in interest in another, if another general partner remains, if no general partner remains after 90 days, unless the partners admit a new general partner in 90 days after association of the last limited partner, unless a new limited partner is admitted within 90 days. Winding up, a limited partnership continues after dissolution only for the purpose of winding up its activities. In winding up, the partnership must discharge liabilities, settle and close partnership activities, and marshal and distribute its assets. Power to bind partnership after dissolution. After dissolution, a partnership will be bound by any acts of a general partner that are appropriate for winding up the partnership. The partnership can also be bound by acts of the general partner that are not appropriate for winding up if the acts would have bound the partnership before dissolution and the party with whom the general partner dealt did not have notice of the dissolution. Distribution of assets upon winding up. Upon winding up a limited partnership, the assets are distributed in the following order. First, creditors, including partners who have loans to the partnership, and second, any surplus must be paid in cash is a distribution. Distribution where assets are insufficient to satisfy debts. If the limited partnership assets are insufficient to satisfy all obligations to creditors, each person who was a general partner when the obligation was incurred must contribute to the partnership to satisfy the obligation. The contribution due in proportion to the right to receive distributions in effect when the obligation was incurred. If a person does not contribute to the full amount required, the other persons required to contribute must pay the additional amount necessary to discharge the obligation. In proportion to the right to receive distributions in effect when the obligation was incurred, a person who pays an additional contribution may recover from any person whose failure to contribute necessitated the additional contribution, but may not recover more than the amount additionally contributed. Conversion and merger. A limited partnership may convert to or merge with another form of business entity upon the consent of all partners and filing a certificate of conversion or merger with the Secretary of State. Limited liability companies. Introduction. A limited liability company is a hybrid business organization that one is taxed like a partnership except for a single member LLC. So remember this because this is the definition. A limited liability company is a hybrid business organization that is taxed like a partnership except for a single member LLC. It offers its owners called members the limited liability of shareholders of a corporation, and 3, it can be run like either a corporation or a partnership. There is no limit on the number of members, as there would be in a subchapter S corporation, a corporation that is taxed like a partnership under the tax code, and no one has to accept full personal liability for the organization's debts as would be required in a limited partnership. Although LLCs are governed by the statute, LLC members may adopt operating agreements to control most aspects of the LLC's business and management. Note that the revised Uniform Limited Liability Act of 2006, RULCA, RULLCA, provides a default set of rules for LLCs. Formation. An LLC is formed by filing a certificate of organization. In some states, articles of organization with the Secretary of State. The LLC must have at least one member. Contents of the certificate are the name, indication that it's LLC, address of the registered office and the registered agent, name and address. Management of the LLC is presumed. That's annoying. Oh my god, there's like 3 more pages. I didn't really know this. I was packing up. Management is presumed to be all members, but the operating agreement may provide for some other type of management, example, outside managers. Each member or manager, if the LLC is member managed, has equal rights in the LLC's management, and a majority vote of its members or managers is required to approve most decisions. Thus, consistent with general agency law principles, each member of a member managed LLC has authority to bind the company to contracts apparently carrying on the ordinary business of the company unless the member lacks actual authority to do so and the other party to the contract has noticed that the member lacks such authority. In a manager-managed LLC, only the managers have such an authority. Member-managed LLC. A member-managed LLC members owe to each other and the LLC duties of care and loyalty. They must also discharge their duties and exercise any rights consistently with any contractual obligations of good faith and fair dealing. Manager's duty of loyalty under, or members, that is, duty of loyalty under what? The duty of loyalty, a member must, 1, account to the LLC for any benefit he derives in connection with the LLC business, refrain from dealing adversely with the LLC unless the transaction is fair to the LLC, and 3rd, refrain from competing in the LLC's business. However, members may authorize or ratify a specific act that would violate the duty of loyalty after disclosure of all material facts. over. It's crazy how it gets busy like this on a Sunday. Members' duty of care. Under the duty of care, members must act with the care that a person in a like position would exercise under similar circumstances in a manner reasonably believed to be in the LLC's best interests. Members who meet this standard will not be held liable for decisions that in hindsight turn out to be poor or erroneous. This is known as the business judgment rule. Manager managed LLC. The duties of loyalty and care are different for managers and members in a manager managed LLC. Although both members and managers must discharge their duties and exercise their rights in accordance with the contractual obligation of good faith and fair dealing. 1. Only the managers are subject to the duties of loyalty and care discussed in A above, and 2. Only the members may authorize or ratify by an act by a manager that would otherwise violate the duty of loyalty. Operating agreement may alter duties. The operating agreement may eliminate the duty of loyalty and alter the duty of care, except to authorize intentional misconduct or knowing violations of law. In doing so, it is not manifestly unreasonable. Similarly, the operating agreement may not eliminate the contractual obligation of good faith and fair dealing, but may prescribe standards for measuring the performance of the obligation in doing so, if doing so is not manifestly unreasonable. Piercing the LLC veil. Members and managers are not personally liable for the LLC's obligations. Courts may pierce the LLC veil of limited liability to reach the members and managers' personal assets to satisfy LLC obligations under circumstances similar to those under which courts will pierce the veil of a corporation. However, failure to observe corporate type formalities, i.e., having meetings, recording minutes, will not be a ground for piercing the LLC veil. Distributions and sharing of profits and losses. Although the roll call is silent on the allocation of profits and losses among members for tax purposes, it does not provide that if an LLC makes any distribution to its members, the distribution must be made to the members in equal shares unless the operating agreement provides otherwise. In most states, however, profits and losses and distributions are allocated on the basis of contributions. A member transferee does not have a right to demand or receive a distribution from the LLC in any form other than money. Indemnification. Members of a member-managed LLC and managers of a manager-managed LLC are indemnified for debts, obligations, and other liabilities incurred in the course of their activities on behalf of the company, provided that they comply with the duties of loyalty and care, and they are also reimbursed for expenses they incur on the company's behalf. That's indemnification. So, rights to information, how they're different between member-managed LLC and manager-managed LLC. Members have the right to inspect and copy and record regarding the LLC's activities, financial conditions, as is just and reasonable if they seek the information for a purpose material to the member's interest. As a member, the member makes a demand to the LLC describing the reasonable particularity of the information sought and the purpose for seeking the information. And third, the information sought is directly connected to the member's purpose. That's for manager managed. For member managed, they have a right to inspect and copy any record concerning the LLC's activities and financial conditions and material to the member's rights and duties. And the LLC and its members must automatically furnish this. So, whereas for the manager managed, there's like 3 sort of hoops to jump through first. That the information is material to the member's interest as a member. They make the demand on the LLC describing with particularity what they want and why, and it's connected to the purpose. The request is connected to whatever purpose they gave in particularity. Last page, members' action against the LLC. I think it's the last page, but I see there's some cutouts. There's some cutout sections. Maybe one page is removed from the book. Members' actions against the LLC. A member who has been injured personally by his LLC can bring a direct action against the LLC to recover. A member may also bring a derivative action on behalf of the LLC if she makes a demand on the other members or managers, unless demand would be futile. For example, a demand would be futile if the majority of the managers or members were involved in the alleged wrong. A derivative action may be maintained only by a person who is a member at the time the action is commenced and who remains a member while the action continues. Transfers of interest. An assignment of a member's interest in an LLC transfers only the member's right to receive distributions. Managers' rights are not transferred. One can become a member, i.e., management rights can be transferred only with the consent of all members or as provided in the operating agreement. So this is like transferring your member interest. Charge of transferable interest attachment. A judgment creditor of a member or transferee of a member may attach the transferable interest of the judgment debtor to satisfy the judgment. Disassociation. A person has the power to disassociate as a member of the LLC at any time, although a wrongfully disassociating member may be liable to the LLC for damages. Generally, the events that will cause disassociation of a member in a general or limited partnership will also cause disassociation of a member in an LLC. Dissolution. Events causing dissolution. An LLC will be dissolved when any of the following events occur. 1. An event or circumstance in the operating agreement states causes dissolution. 2. The consent of all the members. Or 3. The passage of 90 consecutive days during which the LLC has no members. Judicial dissolutions. The court may grant an application for judicial dissolution if the conduct of all or substantially all the LLC's activities is unlawful. It is not reasonably practicable to carry on the company's activities in conformity with the certificate of organization and the operating agreement. C. The controlling members have acted, are acting, or will act in a manner that is illegal or fraudulent. Or D. The controlling members have acted or are acting in a manner that is oppressive and was, is, or will be directly harmful to the member applying for dissolution. Administrative dissolution. The Secretary of State may dissolve an LLC administratively when the LLC fails to submit the required fee or annual report. The LLC may apply for a reinstatement after correcting the problem. If reinstated, the LLC will resume its activities as if the administrative dissolution had never taken place. So I'd be lying if I said that was the end, because it's probably not. Because there's probably a page missing, and that particular page I'm going to read because I believe it sets forth the differences between the different kinds of partnerships. So I'm going to go inside and look it up. So actually a lot of charts on the wall about partnerships. So this is page 23. 24 talked about the effective dissolution. An LLC that has been dissolved continues in its existence but is not allowed to carry on any business except that which is appropriate for winding up its activities. Barring claims against the LLC, a claim can be asserted against a dissolved LLC even if the claim does not arise until after dissolution, to the extent the LLC's undistributed assets. If the assets have been distributed to the members, a claim can be enforced against each member to the extent of the member's proportionate share of the claim or the extent of the assets distributed to him, whichever is less. Note that members' total liability for creditor claims may not exceed the total amount of assets distributed to him after dissolution. An LLC can cut short the time for bringing known claims by notifying claimants in writing of the dissolution and giving them a deadline not less than 128 days in which to file their claim. The time for filing unknown claims can be limited to 5 years after publishing notice of the dissolution in the newspaper in which the county where the LLC's known place of business is located. So, this is funny because this page includes everything that I really wanted to talk about, because alter ego, they said that you can pierce the veil of an LLC for the same reasons that you would be able to do so for a corporation. And I was interested in bringing them up, and so we can go into it. So alter ego is apart from piercing the corporate veil, tort and contract law matter to likelihood of recovery. Business used to perpetuate fraud and assert fraud to recover from ADCO. Okay, so this is taken from a essay, but the point is you can pierce the corporate veil if the partnership was like undercapitalized and the entity is being used to perpetuate fraud, or is being abused, and there's no formalities, wasn't a reason for partnership. We did read that, but situations when the alter ego doctrine would be triggered is if there's no proper separation between the member and the LLC's assets. They're like, say for instance, commingling assets of the partnership or the LLC are being used for personal expenses of the member, and then the member is like exhausting the funds of the LLCs. The LLC is insolvent, not able to pay its creditors, and in such cases, creditors may pierce the corporate veil and obtain what is due to them from the member who's behaving as if their LLC is like their personal property. For general partnerships, limited liability partnerships, and limited liability companies, what's most important is distinction between all of these is, I was actually hoping to read the definition of each and all. So we know this is a partnership is an association of two or more to conduct a business for profit. A limited partnership is ultimately the same, except there's at least a limited partner and a general partner. The limited liability partnership doesn't have that stipulation there. There's at least a limited or a general partner, but all the partners have limited liability. And then in a limited liability company, this is let's read it from the book because we just read that section. The reason this is important is because pretty much every essay that you write really needs to just go through an analysis of what it is. So the LLC is a hybrid business organization that is taxed like a partnership, offers its owners, called members, the limited liability of shareholders in a corporation, and can be run like either a corporation or a partnership. It would be like adds two directors. There's no limit on the number of owners and members as there would be in a subchapter S Corp. So that's ultimately going to be it for the partnership reporting.